Welcome to this employer compliance webinar on managing a medical incapacity process, presented by Employer Pro, empowering employers through effective people solutions. My name is Kent Duffy, employment law specialist and director here at Employer Pro. Employer Pro at a glance. Employer Pro protects employers via effective people solutions. We offer a cost-effective membership model with optional benefits. We have a suite of legally compliant employment documentation, including guidelines, webinars, walkthroughs, and templates for key employment processes. We offer employer support, assistance, and representation. We assist employers to navigate workplace compliance and employment laws. In terms of an overview of the key discussion points regarding this webinar, we'll be looking at what is a medical incapacity process, key legal considerations and risks, the importance of medical information and informed decisions, the formal consultation process and key steps required before an employer can get to a point of justifiably terminating employment on grounds of medical incapacity, Employer Pro's resources for managing a medical disengagement process, along with practical hints and tips. What is a medical incapacity process? It is a formal process used by an employer where an employee is medically unable to work or where their work is materially impacted due to health or medical reasons. Typically, it's a process that is used by employers where an employee is unable to work long-term due to health reasons or issues. It is appropriate to consider this process where the employee's health is impacting their job or otherwise adversely affecting the employer's business and operations. The key considerations associated with this process is that it is still a legal obligation on an employer to formally manage a procedurally fair process, and that includes having regard to a range of considerations such as accommodation timeframes, how long to accommodate an employee's absence in circumstances, say, where they're injured or they're recovering from some sort of medical condition, the employee's length of service. Has the employee been employed for a short amount of time, or conversely, have they been employed for a very lengthy or significant amount of time? And how does that inform the accommodation periods, or how long a fair and reasonable employer should be giving that employee the chance to recover and return to work? The nature of the health issue or medical issue involved, the employee's medical prognosis. This is a really important one, including the provision of medical information, along with the formal consultation requirements, etc. Check out Employer Pro's ebook or comprehensive ebook on managing a medical incapacity and disengagement process for more information. Key legal considerations. The Employment Relations Act 2000, namely Sections 4, which deals with the legal obligation of good faith, and Section 103A, which prescribes the test of justification, is of crucial importance when looking to terminate an employee's employment on grounds of medical incapacity. Fair process is paramount. To that end, refer to the ebook that I mentioned before, the step-by-step guidelines, template letters, and documents for further guidance. Case law principles are also relevant to informing this area and factors that the employer and employers should have regard to when managing a formal medical incapacity process. And broadly, principles arising from case law boil down to, or call it, the stage at which the employer can fairly cry halt, having regards to the various considerations that inform this area. And those are explained or canvassed in the ebook that I mentioned earlier, so you can refer to that for further guidance or support. In summary, an employer does not have to accommodate an employee's absence indefinitely, but must accommodate or must fairly accommodate and give the employee a chance to recover. So generally, the standard advice in a medical disengagement process is to ensure a minimum accommodation time frame of at least 3 months. It could potentially be more in some circumstances, but give that employee the chance to recover and return to work at full capacity before ending their employment on grounds of medical incapacity. That is a key or essential consideration in this context. The importance of seeking informed medical information, namely a comprehensive medical report around the employee's prognosis and recovery timeframes, that will inform any basis to terminate. For example, if that report comes back and is indicating that the employee, there's no foreseeable or feasible prospect of them returning to work in the foreseeable future, then that information could be helpful for an employer to inform the basis to terminate employment. Conversely, if the medical information comes back saying that the employee will be able to return to work in the foreseeable future, then the employer may not be able to proceed any further with a medical disengagement process. Other considerations include the impacts on the business, the employee's length of service, which I mentioned before, and again the point about reasonable accommodations. These things are explained in detail in the applicable ebook that I mentioned. Legal risk at a very high level, where things go wrong or an employer fails to correctly or thoroughly manage a medical disengagement process, can lead to successful personal grievance claims and other legal claims, including remedies for injury to feelings compensation, or so-called hurt and humiliation, lost wages, legal costs. In some cases, the remedy of reinstatement may be pursued in the event an employee is dismissed and they believe that they are entitled to their job back, etc. And along with that, penalties for things like breach of good faith, etc. So at a very high level, things to be wary of when embarking on a termination procedural process concerning the area of medical disengagement. Other practical risks are the reputational consequences that attach to cases. So often they're a matter of public record and are often reported on by various news and media outlets. Then you have the management time and stress with dealing with litigation as well to factor in. Importance of medical information. So seeking, or the employer seeking, provision of a comprehensive medical report is key to any sound or good medical incapacity process. This requires consent by the employee for the release of their personal health information. So they need to agree to that. In terms of the employer toolkit or the employer resource pack, we have various letter templates, including a declaration or consent form for employees to sign in this context. In terms of the relevance of medical information, really the focus is on the employee's current and future health prognosis. And this includes understanding their recovery timeframes and when they're going to be able to return to work, if at all. Medical information will inform any basis to terminate employment. So again, the focus is on that. The employer has to make every reasonable effort to get informed medical information or a medical report on an employee's health or medical situation before they terminate employment on the grounds of medical incapacity. In terms of a very high-level overview on what's involved by way of the formal consultation process and key steps when managing a medical disengagement process or medical incapacity process, the first step is generally checking key documents, so the employment agreement, workplace policies, these sorts of things, and then consulting with the employee with the view to seek medical information formally from them and their doctor by way of, like I said, the recovery timeframes, the prognosis, these sorts of things. Really the goal or the end game that the employer wants is something in writing from the medical professionals with reference to the work or job that the employee performs around when they're going to be able to be fully fit to return to work or come back to work at full capacity, if at all. The second step is scheduling a formal consultation meeting with the employee with all the usual procedural caveats, opportunity to seek independent advice, fully informed, provided with access to all relevant information in advance, etc. So basically an exploratory meeting where the parties can have an open discussion in good faith around understanding any matters of relevance or importance associated with the employee's health situation or injury or whatever their health reason is that's preventing them from working at full capacity, and other matters including their recovery timeframes, returning back to work, etc. Step 3 is generally the employer will have to consider all the information that's provided, including the relevance of a medical report or comprehensive report if that has been provided, and then looking to arrange a formal final meeting. If it's the case that that medical information demonstrates that there's no foreseeable or reasonable prospect of the employee returning back to work after the employer has fairly accommodated their absence and they've commenced their formal consultation process, then only at that point generally you would be formally proposing or consulting with them around termination on grounds of medical incapacity. And again, the letter templates and things like that Employer Pro has all of these procedural fairness requirements and key pieces of information that I'm speaking about embedded into it by default, so they're quite helpful in that respect, along with step-by-step guidelines. Step 4, generally after the employer has completed the formal consultation process, then again it's incumbent on them to consider all the relevant information, and if nothing changes and it's unlikely or the medical evidence or process proves that the employee is going to be unable to return back to work and the employer can demonstrate that it can no longer reasonably accommodate that, then we're at the point where the employer can notify the employee of termination for medical incapacity or due to medical reasons. Final point on the slide there is that use Employer Pro's step-by-step guidelines, template letters and documents, and these are in the ebook on managing a medical incapacity and disengagement process. So as I mentioned, Employer Pro has a range of resources and tools available to help employers, including comprehensive ebooks, step-by-step guidelines and walkthroughs, concise practical employer toolkits for managing key employment process, including medical disengagement, template letters and documents, webinars and training videos like the one that you're listening to now, employment documentation, Employer Pro's employment agreements and workplace policies, and of course access to further advice via advisory consultations or hands-on support through formal terms of engagement or consultancy arrangement if required. Practical hints and tips. So as an employer, when embarking on any sort of medical disengagement process, or if you're otherwise looking into issues associated with this area, then the starting point is always to check your workplace documentation carefully. So what does the employer's employment agreement state? Does it have anything prescriptive that the employer has to have regard to or implement as part of its overall general process? What are the obligations prescribed there? The same applies for any workplace policies or employee handbooks with information relevant or on point. Ensure the employee is given a fair opportunity to recover. I mean, this is relatively common sense, but you know, the example to use is, say if you've got an employee and they suffer some sort of injury, perhaps a broken bone or something like that, and they're off for a period of time. You know, I have had scenarios where the employer, you know, rings up on the second day of absence and says, I need to get this process underway and look to terminate on grounds of medical incapacity. And of course, in that sort of scenario, there hasn't even been a fair opportunity for the employee to make a recovery. So the starting point is to give the employee that opportunity. So there has to be a reasonable time frame depending on the issues involved for the employee to make their recovery and return to work. That's the key point before the employer starts its formal consultation process. The employer must make reasonable attempts to obtain sound or complete medical information and be prepared to pay for the costs associated with obtaining a medical report, since it's the employer that's requesting that as part of managing its employer or employment process and associated legal obligations. Of course, considering any alternative or suitable alternatives to dismissal, these may vary or can involve a range of things like perhaps a mutually agreed variation to an alternative role, temporary or permanent, gradual return to work if that's possible, light duties for a period if that is possible. It's important for the employer to turn its mind to whether there's any suitable alternatives prior to dismissal, as you know, generally the default position is that termination on grounds of medical incapacity would be a last resort sort of scenario to end up in. So turn your mind to those alternatives before proceeding with any sort of dismissal or procedure. Patience, due diligence and planning is key to any sound employment process. So again, read Employer Pro's ebook. It's comprehensive, it's very detailed. There's a lot of practical and useful information in that employer resource pack, and that's on managing a medical incapacity and disengagement process. Use the template letters and read the documents, follow the step-by-step guidelines when navigating this particular employment process with an employee. In terms of disclaimers, this webinar is for guidance and information purposes only. It does not constitute formal legal advice. Employer Pro Limited is not responsible for any liability or otherwise arising out of the use of this webinar. Seek professional advice or support from Employer Pro Limited by becoming a member today, if further assistance or support is required. Employer Pro, supporting employers. Visit www.employerpro.co.nz or email info@employerpro.co.nz for further information or assistance.